All right, so let's deal with this story coming out of Manhattan. The district attorney has dropped murder charges against Jose Alba. So Jose Alba was a convenience store worker, or I suppose is because he's still alive, unlike the person that he killed who was trying to kill him first. So Jose Alba is working behind the counter at a bodega, and this image that you see on screen is from behind the counter. So this is in the restricted area of the store. And this man who has entered the store has entered because his girlfriend earlier, not much earlier, but earlier tried to come in and buy a bag of chips, like $3. She was trying to use EBT. She was trying to use food stamps. The card was denied. I'm not sure why, but it was. And so then he's coming in. So a boyfriend comes in here into the restricted area, into the back room, pushes Jose down, grabs him by the neck, is fighting with him, and Jose here defends himself with a knife and kills the person who was trying to harm him. And he was charged with murder, which was insane. It was insane because it was clearly self-defense. He was in this confined space. He was being aggravatedly assaulted. He was in fear of his life. And, and he defended himself. And yeah.
All right. So this is the legal piece versus my opinion. So I want to make it very clear. I have two separate pieces on this. My opinion is that this arrest was nonsense. It's clearly self-defense, right? We all agree. It's clear. Somebody comes behind the counter, roughs you up, and then grabs you by the collar. He's got self-defense claim is easy. But then there's a legal piece to it. Should he have been arrested? What's the implications of that? Well, in New York, technically, and I hate saying this, but technically, the arrest was legitimate, just based on the law. See, a lot of people don't understand. Self-defense is a defense, just like with copyright, right? If you have a copyright claim and someone says fair use, they're essentially saying, we are using your work, your material, yes, but we have a legitimate defense to using it, right? So they are essentially saying, I did that thing, but I have a legal defense. And now the way you find out if that defense is legitimate or not is a court has to find, okay, this is fair use or this is not fair use. The same thing here is that when you say, I have a claim to self-defense, that's a defense, but saying that I did do the thing. So if you're talking about so a couple of people were asking me, well, can the prosecutor be charged? This. The reason why they can't, because only thing you need is probable cause, which is extremely low standard. And here, you do have him stabbing the person that was, even all the circumstances, but what the DA is saying was, well, you admitted, you killed him. We got it on camera. So now is your defense viable? So the arrest was legitimate, but I think, though, and a lot of states have made it very clear that they don't through the stand your ground laws that say, okay, we're not going to make these arrests legitimate through stand your ground laws to say, if it's obvious that this was self-defense, then we're not going to, you can't arrest this person. You have to now then go to proving this wasn't self-defense before you can make an arrest. We're here in New York, you don't have that stand your ground law. So if you are in a self-defense situation where you have to protect yourself, unfortunately, you are admitting to committing that act and now have to go in front of the tribunal and say, this is why it's lawful. And also, just to be clear, in New York, it's the district attorney's office who has to prove you didn't act with lawful self-defense. And that's where, obviously, this case falls apart. Because there's no way they can prove this guy didn't act with self-defense.
Mm-hmm, mm-hmm. Yeah, I mean, what the arrest doesn't bother me as much as the initial decisions from the district attorney, who's in a position which affords more reflection. So the beat cop trying to make a decision in an instant about what's going on. Well, someone is dead, so there's pretty good evidence that, there's a homicide, and then you're into self-defense as a justification. So that's the issue. There's in fact outstanding evidence there's a homicide. It is a homicide. The only question is whether or not it's murder. So, and that gets into the difference between a justified homicide and a non-justified homicide. So asking the officer on the beat to make that initial determination, if you want to say the arrest is valid, I totally understand. Where my sympathy sort of breaks down is the district attorney, who's in a position of calmer reflection, who has the ability to review the videotapes and for several days was going on to prosecute this case, asking exorbitant bail, despite having evidence that upon calmer reflection would readily indicate this is self-defense. How the beat cop in the moment is supposed to make that determination in all but the most blatantly obvious of circumstances, I get it. So if you want to say the arrest is valid, I totally get it. If you want to say the district attorney in terms of their actions is legitimate, I'm going to have a much harder time because the district attorney has the availability of time and more information.
Oh, I agree with you 1,000%. But I also think too, in this case, this is where you start seeing selective enforcement, law enforcement, because let's say you get to the scene. You got someone dead, someone stabbed, and the person who stabbed them with literally the guy's blood on his shirt and saying, I stabbed the guy for self-defense. You're going to jail, right? You're going to they're arresting you, right?
The bloody knife is in your hand is pretty good evidence to the cop that, you just committed. It seems to be prima facie evidence of a murder. I would tend to agree, yes.
Yeah. So I think probable cause is out. And remember, that's the standard, probable cause. No matter what, there's a lot of people out there saying reasonable suspicion. If somebody tells you the standard for
not for arrest, you need probable cause for arrest.
Yeah,
not for arrest.
That's
if you're saying if anyone says reasonable suspicion, they are wrong.
There are a lot of people out there saying reasonable suspicion, but
they are wrong, my friend. They are wrong. If you want to do an arrest, you need probable cause. Not that that's a problem here, by the way, because once again, bloody knife with blood on the shirt and all the rest of it.
I did it, and here's the video camera to show that
probable cause is looking pretty good.
Yeah, probable cause is out the window. But I think the selective enforcement here is you also had that with the girlfriend who stabbed,
who isn't being charged, even though there's pretty good evidence to charge her, because we have statements from her, and the statements, the exact language that she used, I'm going to send him in to F you up, seems to suggest she has knowledge and a plan to engage him. He's moving into the restricted area of the store, which apparently in New York qualifies for burglary, right? Classically, burglary, if you need two things, you need an unauthorized entry and intent to commit a crime once you're there, and usually a felony, more specifically. So he's authorized to enter the store, so that part isn't burglary. But when he goes into the back counter area, according to Nate, and he would know because he was a prosecutor in New York, that is sufficient to be an unlawful entry, because now you're entering a restricted portion of the store. Okay, so you've got the trespass portion. Great. So now all you need for burglary is to show that they're doing that with an intent to commit a crime therein. When you have her saying, I'm going to send this guy in to beat you up and all the rest of it, it sounds to me like you're planning on an assault and battery. And so that seems like that would legally qualify as burglary, which makes her an accessory to burglary. And then because of the death that ensues, I don't know whether or not that qualifies as felony murder, but you're at least you're thinking to yourself felony murder, because now you got the underlying burglary as the underlying felony for felony murder. But the DA had no problem deciding not to charge her. Now, to be fair, she has affirmative defenses to some of it, because she might have thought she was acting properly, but then again, you can't be the one that instigates the problem and then claim self-defense. So even her self-defense claim isn't rock solid. But the DA had no problem clearing her, even though her case is more tenuous than the shop owner's case.
To be honest with you,
there seemed to be some bias in those charging decisions.
When she first initially entered the store and tried to buy whatever, and that happened, right? And then she goes back and says, I'm going to get somebody in to beat you up, right? And then she leaves and brings that person back. Now you have, again, and I'll go to the statute. It says a person is guilty of burglary in the third degree when he knowingly enters or remains unlawfully in a building with intent to commit a crime. This woman leaves
Yes.
and gets someone and enters and remains
Yes.
unlawfully with the
Yes.
intent to have her boyfriend beat up the store clerk. So it's just, so think about this. If, let's say if she said, I'm leaving, I'm gonna get my boyfriend to come rob this place. And he comes and does the same thing. And then this happens. And then she stabs him. Well, there would be no question that she would be charged with the boyfriend's murder because she instituted all this. And on top of that, this would be a felony murder case because he was killed in the commission of the felony, which she was also assisting in, right? She came back with him to show, hey, this is the guy who did this, beat his ass, right? So I think if she was to be charged, which she should be charged, she would easily have to go through a trial and couldn't use self-defense because you were the one, you were essentially in the middle of the commission of this felony and you have no right to self-defense. Just like if they were robbing a bank and she could say, oh, the security guard was stabbing my boyfriend, so I wanted to stop him. I was defensive of my boyfriend. Well, you can't defend them because you're robbing the bank. So, this whole theory of the girlfriend having a great self-defense something. I know a couple of people.
I didn't say it was great. Never claimed it was great.
No, not you. But I think, to be honest with you, she has no self-defense claim. And that's the issue, I think, here with selective enforcement of law is that anyone who's watching this, if you are going to arrest him for stabbing this guy and you got clear self-defense and you can, we got probable cause, there is no way that you can then tell me that there is not probable cause to arrest this woman and there's not probable cause to deny her self-defense. It's there. And I think you can also prove beyond a reasonable doubt that she initiated this. She went there to commit a crime. She was definitely an accessory to it. And someone died during the commission of this felony. That would be my argument.
At bottom line, she's reckless because she's sending her boyfriend in with the purpose of apparently beating him up. So that's reckless disregard. So that's murder 2, 125-25, if memory serves correctly, off the New York citations for reckless murder under second-degree murder. The fact that we're able to clear her when her claims are legally dubious and prosecute him when his claims are so legally clear shows backwards cuckoo Cocoa Puff land, apparently in the New York District Attorney's Office.
Well, that's because he sees, I think the district attorney wants, it's race, I think, has something to do with it too, right? Mm-hmm. And I think that's part of the issue here because, again, it's a shame.
Let's read a little bit more about this because it actually uses some of the actual quotes. Let's going on here. Around 11 p.m. on July the 1st, Simon enters the store shouting profanities at Alba. After Simon's girlfriend's payment was declined for a bag of chips. The fact that this is over a bag of chips is hilarious. Apparently, she was all that. She was only missing the bag of chips.
The bag of chips. That's all you were going with that. I like it. That was good.
Okay. Simon came behind the cashier's counter, shoving Alba, hovering over him, and appeared to try to forcibly remove him from behind the cash wrap. That would be the restricted area of the store. Alba subsequently grabbed a knife and stabbed Simon, ultimately killing him. Additional surveillance footage shows Simon's girlfriend telling Alba that Simon was about to come in and fuck him up. There's your burglary. I am sending him in for the purpose of beating you up. And now we've got the trespass into the restricted area of the store. That, my friend, legally qualifies as burglary. Now we've got a death in furtherance of the burglary. That, my friends, is felony murder. We've got her as an accessory to all of that. So, okay. So these decisions seem quite bizarre to me, and I don't suspect the district attorney is going to go back on his decision not to prosecute her, although he could, because there's no statute of limitations, and it's not like she's changed her position in some sort of reliance. They sent Alba to Rikers Island and sought $500,000 bond to keep him there, even though, once again, he was pushed down, confronted, aggravated assault, grabbed by the neck, self-defense. This is bizarre. In Texas, we give this guy a fucking medal. In New York, apparently, we prosecute him. It is messed up.
I think the arrest is just kind of performer. Like the guy's gonna be arrested, right? It's like I think you got no choice. If you're a cop on it, you go to the scene and it's a dead body. you kind of have no choice at that particular point. But
Okay.
I also think on the back end though, this girlfriend thing is really pissing me off because I don't see how she can't be even be charged. Like she's not been charged with anything yet.
Yeah.
Like I don't see how you can defend that where you sent this guy with $500,000, $250,000 bail, and you're talking about bail reform.
Now, I saw this question pop up a couple times in chat, so it's a good opportunity for legal education as always. People asking, is there non-felony murder? LOL. And see, this is like, no, it's a good question because
great question.
It is a good question because felony murder is a doctrine that is I don't know if it's unique to the U.S. I think there might be one other country that uses it. It's definitely not something that's used in. Yeah, we're one of the few. And it's not something that's available in every. It's not something that's available in every state. But let me tell you what felony murder is. We're gonna have a slideshow from Nate the lawyer, who's going to explain to us all what felony murder is. This is good stuff.
Yes, I have felony murder on steroids. Oof. Okay. Oh my God. Felony murder. Let me make sure I see what I got. All right. So these are some examples of felony murder. So felony murder, you need someone who's doing what's called an inherently dangerous felony. So not all felonies work for felony murder. We're talking about felonies that are inherently dangerous. So your robbery, burglaries are considered inherently dangerous. Those type of felonies. There are other felonies, let's say like embezzlement. If someone dies, if you're embezzling them, that's not felony murder. Yeah. So we're talking about felonies that are inherently dangerous. And we're also talking about there's a death that occurs. Now, one thing with felony murder, it doesn't have to be one of the suspects that die, or doesn't even have to be one of the people, let's say if you're in a bank robbery situation, it doesn't have to be people it can be anyone, any death that occurs during a commission of the felony. One of the robbers, innocent bystander, cops, the person who's engaged in the felony is charged with that murder. And those
are there non-inherent dangerous felonies? Are there non-inherent dangerous
Yes.
felonies? Yes, as you said, embezzlement, for example.
Embezzlement,
white-collar crimes. So there's a lot of felonies that don't require violence. So yes, there are a lot of felonies that don't require violence. We're talking about crimes that basically, by their nature, either require or strongly imply violence: robbery, burglary, sexual assault, arson, if memory serves correctly. So those are the kind of thing we're talking about.
So here are some examples. First, let's say you have a police, two people robbing a bank. Police come and kills one of the robbers. The robber who survived is going to be charged with the death of the other one, even though the cop killed him. The robber who's charged, and this actually happened. This is what these two guys, they were involved in a robbery, and the police killed one of these guys, and the other guy was convicted of a life sentence for felony murder.
This is the key distinction between murder and felony murder. For murder, you have to basically intend someone to die. You have to do the thing that causes them to die. That's murder. Here, we're not arguing that the person did anything to kill the other person, right? We're not arguing they performed any acts of murder. All we're trying to prove is they were committing an inherently dangerous felony and someone died in the course of that felony as a result of the felony. So it doesn't matter that they didn't pull the trigger. It doesn't matter that they didn't even have a gun. The police officer is the one that's doing the shooting. That's felony murder of the suspect, right? That's what felony murder is. It's a death that occurs in the furtherance of a felony. So you don't have to prove any intent to kill. You don't have to prove any intent to even really harm anyone. You just have to prove that you were committing an inherently dangerous felony and someone died and you're there. That's felony murder. Again, this is a special rule in the United States. I think we might be the only country that uses it. There might be one other one, but it's a special thing in the United States. So
it gets crazy here in the United States. So, for instance, let's say we have,
depending on your point of view.
Well, here's one case. Look, here's another example. Let's say someone lends his car to a friend, right? But the issue is the person knows the person's going to go rob somebody. Right, or going to go commit a drug robbery. So
I am lending you my car with knowledge.
Go do your drug robbery.
That you are going to commit a robbery. Fantastic.
Using that car.
So that makes me an accessory to robbery.
Correct.
because I'm
Now,
I'm aiding and abetting you. I'm providing you
correct.
instrumentalities and aid. I'm furthering the robbery. Thus, by me providing the car, just that, I am now an accessory to robbery. Please continue, Nate.
But now, let's say then you go to sleep.
I'm asleep counting some Z's as you're off doing your robbery thing. Great. No problem.
Yes. Then they use the car. Somebody dies during the robbery. Felony murder.
Right.
Yes.
Felony murder. Right.
This person.
I am asleep in bed at the time. I'm nowhere near this. I'm guilty of murder. I didn't think anyone would die, but someone did die. I aided in the bed of the robbery. I am guilty of murder.
And this person is doing a life
Yep.
sentence. And this is the facts of this case. The person was sleeping in bed. Felony murder.
A mile and a half away, asleep. And they're guilty of murder.
Yeah. Guilty of murder. So remember, it's and in this case, this was the felon. This was with the Chauvin case.
So this is what we're talking about when we say felony murder, right? And people are like, "Is there such a thing? What's a non-felony murder?" Right? It's a term of art. Right? Because we're not trying to prove that Alba intended anyone to die. Fuck him up can mean a lot of different things, right? And not necessarily like any intent to kill. So we don't have to conclude that Alba's girlfriend, Simon's girlfriend, rather. We don't have to prove that Simon's girlfriend intended anyone to die. That's the magic of felony murder. We just have to prove that she is committing an underlying felony. So we go back to this and say, we're sending you in to fuck you up. Now that can mean a whole lot of things, but it definitely means battery. So we're sending you in with the purpose of committing the battery. And now we're sending you in to a restricted place, right? This is a difference also, incidentally, if it happened in the main area of the store versus the back room of the store, it makes a difference where the thing occurred, right? So if the clerk is in the main area of the store and this all occurs, there's no burglary because she's not in a restricted area. She comes into the place that everyone has the right to be. Anyone can walk in the door at any time. It's not trespass, so there's no burglary. Because he's standing behind the counter in a restricted area of the store, for him to enter that back area, that's a trespass. He can't be there. So now we have trespass with intent to commit a crime therein, battery. That makes it burglary, right? Burglary doesn't require you to steal something. Obviously, that is a kind of burglary, right? You're going to commit a theft. That's what people think burglary is, but it's not the only thing burglary is. Burglary is when you trespass with intent to commit any crime therein. So you are now entering a restricted area with the intent of beating them up. Now you have burglary. Now you have death in furtherance of the burglary. That's a felony, inherently dangerous felony, plus death. Bingo, you've got felony murder. So even though she might not have intended the death, even though she might not have thought of death, even if she did nothing to actually create the death, that's felony murder. It's a uniquely American rule. And whether or not you think it's good or not depends a lot on your disposition. I personally think it's a good rule, but that's me. People have disagreed with this philosophy.
In felony murder, some states, there's what's called the merger doctrine. And the merger doctrine is simple. It says that for certain crimes, there has to be an underlying crime for you to commit it. So, for instance, with robbery. For you to commit a robbery, you have to have the underlying crime of theft, right? So in other words, I'm trying to take something from you. So if there's no theft, there is no robbery, right? It's a simple concept.
You have to take something in order to rob someone. And incidentally, for what it's worth, you have to intend to permanently deprive them of it because you need the larceny. So if you plan on giving it back, it's not robbery. So fun times.
So what happens is that like with larceny and robbery, for instance, larceny is a prerequisite. You have to have a larceny to have a robbery. So the merger doctrine says you can't charge the person for both larceny and robbery. You have to charge for only the robbery. Now you could charge as a lesser included offense, but generally the larceny merges into the robbery because since it's an element of the crime. So usually you'll see people only charged with robbery at varying degrees of robbery instead of being charged with both robbery and the larceny. Now, the same thing is true for murder. For every murder, there's an underlying requirement of assault. You have to, all murders, you have to commit an assault for any murder. Now, generally,
it's pretty hard to kill someone without assaulting them. This is true.
Yes, it's impossible. It's literally impossible. So generally, when it comes to felony murder, most states, if you're committing an assault and the person dies, the state doesn't allow you to charge a person with felony murder where assault is the underlying crime. You went there to commit an assault, the person died, so they won't allow you can't get felony murder through that process.
Right.
But certain states do allow that. For instance, like with Derek Chauvin. Derek Chauvin committed an assault on George Floyd, but since George Floyd died in the commission of that assault, which everybody says is an assault, they were able to elevate it and charge him with felony murder. So it's a weird little consequence in certain states where they say we don't care about the murder doctrine. If you're assaulting someone and a person dies, we're going to charge you with felony murder. Now, generally, in the way it works here, like here in New York, if you're assaulting someone and he dies, they'll just charge you with like a second-degree murder charge, even a manslaughter charge. But and those are usually, you can get something like 10 to maybe 15 years in prison for that. Felony murder is just like second-degree murder, so you get like 20, 30 years for that charge. So in those states, life in prison.
You can even get the death penalty. You can even get the death penalty for felony murder. Now you get a little bit more nuance there because you have to show that they're like a major contributor and stuff for constitutional concerns. But you can even get the death penalty for felony murder. So even though you didn't necessarily intend to kill someone, and it maybe even if you didn't kill someone, we can still get you the death penalty for the murder, or at least the death that resulted. So yeah, felony murder can be a real bitch. Basically, don't commit underlying inherently dangerous felonies. Is a great legal rule here. This all only applies if you're committing inherently dangerous felonies. Don't do that, and you'll be fine. Also, the inherently dangerous felonies themselves are very illegal. I'd like to point out, so don't do that.
Yeah. But the thing is that I agree with the felony murder rule as long as there's a murder doctrine, right? You were complaining about the damn murder doctrine too, and you're like, I can't believe this. So I think we all agree with the felony murder principle, but as long as there's a murder doctrine, so you can't have simple assaults.
Yeah, the felony murder without a murder doctrine was blowing my mind. I had to read 5 different Wisconsin Supreme Court cases before I was really willing to believe they didn't have murder doctrine because it blew my mind so hard.
Let's say you are in a park, and let's say you want to have fun with a friend. So you go and you say, okay, I'm going to slap him in the back of the head. And you slap the person in the back of the head, and the person falls and hits their head and dies.
Mm-hmm.
Generally, you'll get, you can get 5, maybe 10 years for that, because it's a manslaughter, you didn't intend it. But with felony murder,
manslaughter to me, yeah.
But felony murder, though, did it happen? Did he die in the commission of a felony of an assault? Yes. Okay. Well, maybe we have an issue here. So it really, really, without the murder doctrine, it really opens criminal suspects up to a lot of liability for, things where they would get maybe 5 to 10 years in prison. Now you're talking about life sentences. So it's really punitive in the fact of when felony murder applies, especially when there's not the murder doctrine.
Mm-hmm. Yeah. So that is felony murder. Now you know way more about felony murder than you ever wanted to know. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.